Hi, everyone. Welcome back. So this week, we're going to cover Chapter 7, Special Needs Searches. But once we finish Chapter 7, then we're ready for exam number 2. So it will include all the information for stop, question, frisk, for search and seizure, will all be on Chapter 2. So it will be Chapter 3, Chapter 6. Just make sure I'm telling you the right thing. Yeah, Chapter 3, Chapter 6, and Chapter 7 will be exam number 2. So it's all search and seizure. I highly, highly recommend you have your search and seizure flow chart with you when you go to take the test. There will be a problem like the search and seizure case study that you had to do. So please have that with you, and you will have to use the IRAC method. So make sure that you understand that. Okay, so let's get on with the material. Now, before you start the lecture, I want you to click on this special needs search class activity. It's just a little worksheet with a bunch of little scenarios. And I want you to just think through each of them and either decide it's individual rights or protecting the public, right? So if it's individual rights, you're going to say they can't do it. They believe it's illegal because the individual rights outweigh public order. And then if you believe that the police can do it to protect the public, right, protect public. So individual rights means you don't think the police can do it because individual rights outweigh that. And then public, protecting the public means is when you think that protecting the public outweighs individual rights and therefore the police can do it. Okay, so read through each of the scenarios and write what you think, just to get you thinking. And then we're going to actually be talking about each of them, spaced out throughout the lecture. So make sure you kind of look at that first. Okay, so when you're all done, start the video and then we will move on to the lecture. Okay, so hopefully you have all done your lecture and you've all looked at it. And that little activity sheet, and you've looked at it and you're all ready to roll. So we are now going to move on to Chapter 7, and we're going to talk about what we call special needs searches. So just a question to get you thinking. Can you think of a situation where police or government can search, or people can be searched without a warrant, even without probable cause? So we have said over and over for the last couple of weeks that you have to have a warrant. And if you have an exception for most of the exceptions, even if you don't have a warrant, you still need to have probable cause. So my question to you is, can you think of any situations where maybe you don't have to have those things? And that's what we're going to talk about today. We're going to talk about what are called special needs searches. So all these rules that I've told you, you must have all these things. Now I'm going to give you all kinds of exceptions of when maybe you don't need to have those. Okay, so when we talk about special needs searches, we're talking about searches that meet 4 basic characteristics. So they have to meet these 4 characteristics if they're going to be classified as a special needs search. I'm sorry, I'm just trying to tilt my camera down a little because it seems so high. Okay. Now, the first one is a special needs search has to be directed at people in general. You cannot pick and choose which people you're going to use for a special needs search, okay? So special needs searches just apply generally to all people. You can't say because of a particular race or religion. You can't say, well, I think this is a suspect, so I'm going to search them. These are searches that every citizen can be subjected to. They're not going to be limited to certain suspects, okay? The second characteristic is you don't need a warrant and you don't even need probable cause, which seems crazy because I've been saying over and over, you need a warrant and the warrant has to be based on probable cause. But these are going to be searches that don't have to meet either one of those criteria. And then I have said, if they do violate the Fourth Amendment, you cannot use the evidence against the person. Well, special needs searches, you can use the evidence against the suspect. So even though we're going to say that they do blatantly violate the Constitution because you have no warrant and you have no probable cause, we're going to say, yes, we're still going to allow you to use this evidence at trial. We are not going to apply the exclusionary rule to these types of evidence. And then finally, the biggest thing about special needs searches is it's always a balance. The courts always have to weigh the violation to the Fourth Amendment, because we're saying these are blatant violations of the Fourth Amendment, but we have to balance that with the need to protect society. And there are some circumstances where the need to protect society outweighs the need to protect individual rights. So that's what we're saying with special needs searches, that you do have Fourth Amendment rights, but these needs to protect the public are so much more important. We're going to let the Fourth Amendment be pushed down a little bit, and we're not going to have to follow all the requirements of the Fourth Amendment. Okay, so it's always sort of this inverse relationship within criminal procedure. Are we going to focus more on individual rights and due process, or are we going to give more power to the government to protect the public? So crime control, protect the government. This balance is really, really important when we're talking about special needs searches, because we're balancing it more towards stopping crime. So we're giving that more importance than any violations to the Constitution. So when we give more importance to the power to police to do things, we're sort of limiting our Fourth Amendment rights to a certain extent. Now, like I said, hopefully you've opened that worksheet, you've done it all, and you've identified either individual rights police cannot do or protect the public police can do, okay? And assume that there is no reasonable suspicion or probable cause that exists with any of these circumstances. So once you're done with that, we're gonna go through them one by one and then use case law to explain what they say. So the very first one is police conduct a search of a car that they have impounded to make an inventory of items in the car and to make sure the car does not contain any dangerous items. So you had to decide, are police allowed to do that towards protecting the public or from crime or from bad things, or are they not allowed to do that? Because that would be searching a car without probable cause. And the automobile exception doesn't really apply because it's not moving. The police already have it in custody. So this is what we classify as an inventory search. An inventory search has been held to be what we call a special needs search. The Supreme Court in South Dakota versus Opperman has said that police can conduct limited inventory searches when cars are impounded. You do not need probable cause. You do not need a warrant. Now, the purpose of the inventory search is to keep the property safe so nobody can steal the property, and also to protect the officers. If they had something dangerous in a car, we would want it to explode or hurt somebody. So we are allowed to search like through an inventory search when we impound cars. Now, it's very, very important to remember you're never allowed to use inventory searches to look for evidence. That's not the purpose. So if your sole purpose is to get in there and look for more evidence, that is not the proper purpose. It has to be just to make an inventory of what's in there to protect the property and to protect the police and the people that are holding the car in impound. Okay. Now, there was another case that came up later, Florida versus Wells. And in this case, sometimes the police would inventory and sometimes they would not inventory. They did not have set policies and procedures. And what Florida versus Wells said is that you have to have standard criteria and treat all people the same with inventory searches. So we can't just pick and choose which cars we're going to inventory. We have to have a policy and procedure for the department, and every car has to be inventoried the exact same way. Otherwise, it just looks like we're there to look for evidence, and that's not special needs. So remember, the first criteria for special needs is that it applies to all people equally. And that would be an example. So you cannot pick and choose. Your department has to have written policy and everybody has to follow that policy. Okay. If you start to pick and choose, then it's not going to be an inventory search and it will be illegal. So during this inventory search, when the car was impounded, can the police also open and look into all luggage and bags found in the car? So you're doing the inventory search, and instead of just writing luggage or suitcase, you're going to open the suitcase and look what's inside. So the Supreme Court had to decide, can you do that? Is that part of an inventory search? Are you allowed to actually open things in the suitcase? And this came up in Colorado versus Bertine. And the court said, yes, police can search containers discovered during the inventory search as long as it's part of that departmental policy. Because you could have something dangerous, a firearm, something that could explode, something like that in the luggage. So again, you're not looking for evidence, you're just making an inventory. So you can say suitcase, and then you can open the suitcase and list all of the things inside of it. That is permissible under inventory search. Okay, so the next one. Police enter the home to check on a child after there was a report of child abuse. So then the courts had to decide, are the police allowed to come in and just check on children? They don't have a warrant, they don't have probable cause. All they have is a report that the child may have being abused. It's not an emergency exception because the abuse may not be right now. It could have been abuse that happened in the past. Remember, for emergency or exigent circumstances, it has to be imminent danger. So the Supreme Court had to say, well, are we going to allow this kind of search? What about this one? Police enter a home to check on someone after they receive a 911 call that the person is at home was threatening to commit suicide. So again, you're going into a home and you're just looking for that person, and you don't have a warrant and you don't have probable cause. What the Supreme Court has said is these do qualify as what we call inspection searches. So it could be a welfare check for somebody that you're worried about is going to harm themselves, or it could be welfare check for children or elderly that are being abused. It could be business inspection. So if you sell alcohol or tobacco or certain other products, they can go in and just do like an inspection to make sure you're following the rules. The fire department, which is also government, can go in and make sure there's no fire hazards. And then international mail, crossing the international borders. Those are all what we call inspection searches. So again, you don't need probable cause. You don't need a warrant. These are going to be special needs searches, and we're going to allow the police to search in these circumstances. Now, what about this? Jerry is a U.S. citizen who is crossing the U.S.-Mexican border to return to the U.S. after a vacation. At the border, ICE searches his car and all the bags in the car. So what about international borders? Again, no warrant, no probable cause. It's just solely based on the fact that you're crossing an international border. So is crossing an international border enough to allow police to search? So again, it is a violation of the Fourth Amendment. You have Fourth Amendment, it would be an effect, no warrant, no probable cause. Just the fact that you're crossing the border, they just want to search. So you do have Fourth Amendment rights, but is there a governmental need that outweighs that Fourth Amendment protection? And the court said, yes, international border searches are okay. Okay. And the idea is that we have to have them, even if they violate the Fourth Amendment, because we need to keep our country safe. So you are going to be able to search anytime somebody crosses the border. The police are going to be allowed, or the Border Patrol are going to be allowed to search that car just based solely on the fact that it was crossing the border. No warrant, no probable cause. But we need to keep our country safe, which outweighs the violation to the Fourth Amendment. So the next one, Tom is a U.S. citizen who is crossing the U.S.-Canadian border to return to the U.S. after a vacation. At the border, ICE seized his cell phone and searches all the items on the phone. So again, no probable cause, no warrant, just the fact solely that they're crossing the border, can they seize your phone and then look at everything on your phone, text, photos, emails, anything on your phone? Do they have that authority? And the Supreme Court said, yes, they do, because it's the need to protect our borders and to people coming in and out of the borders. Now, the Fourth and Ninth Amendment or circuits say, no, you can only do it with reasonable suspicion. So ICE and CBP are saying, yes, we have the authority to do that. We interpret the special needs search to allow us to do it. The Fourth and Ninth circuits have disagreed and say, no, you need some suspicion. Maybe we won't require probable cause, but we are going to require some level of proof. So we say you need reasonable suspicion. This has not been decided by the Supreme Court yet. It's a pretty big issue, but it's not actually decided. So we don't know which side the Supreme Court is actually going to come down on. So what about this? What about strip searches at the border? Patty was recently on a vacation in the Middle East. When she lands at the airport, she's taken by ICE and made to strip within a private room so that ICE can check to make sure she's not transporting bombs. So are they allowed to actually strip search you? So we know they can search you, but does it extend to strip searches? Is the need to protect the border outweigh that much more intense invasion in somebody's Fourth Amendment rights? And then so strip searches are permitted as long as there is some reasonable suspicion that there is a weapon. So remember, regular searches when you're crossing borders, you don't need anything. You don't need a warrant. You don't need probable cause. You don't need anything. If you're talking about a strip search, it's a much more intrusive search into the person's body, which is Fourth Amendment expressly protected. So the court's going to say, since it's much more intrusive search, we're only going to require, we are going to require reasonable suspicion in order to conduct those searches. Okay, now let's take it one step further. What about a body cavity search? Okay, now this is when they make you actually strip and then check your body cavities. The Supreme Court has said body cavity searches require probable cause. So if you think about it, it's even more intrusive than a strip search. Since it's more intrusive than a strip search, we're going to require probable cause. So we have Fourth Amendment. We need to protect our country. For regular old searches, protecting the country outweighs it, right? Strip searches, it's more of an intrusion on your Fourth Amendment. So we're going to require a little more along the lines of some level of proof, reasonable suspicion. Then you get to body cavity searches. That's a huge infringement on Fourth Amendment rights. So we're going to require some level of proof. We're not going to allow them to just do it. So you need at least probable cause. Now, what about at an airport? So Robert is planning on visiting his mother in Florida. When he arrives at the airport, he is searched and all his bags are also searched. Is that permissible? So Fourth Amendment violation, they're searching you and your bags, no probable cause, no warrant. Is there a governmental need to protect the public and to allow that kind of search? And the Supreme Court said yes. Okay. Special or all airport searches, like when you're crossing to go onto a plane, they all are special needs searches. They're a minimal intrusion onto your privacy. So they are going to require you to do that in order to keep people safe. So that's why you have to go through baggage check. They scan your bags, they scan you. Now you have to stand and they, sometimes it's metal detector, sometimes they're using that other equipment. It is an infringement. It is a violation of your Fourth Amendment rights, but the need to protect society outweighs that infringement. And you can always decide you don't want to fly and not have to go through it. Okay. Do high school students have the same Fourth Amendment protections that adults have? So now we need to think about students and what protections students have, okay? So you would think, yes, they have the same Fourth Amendment protections that adults have. But the problem is when you're at a school, there's lots of different people around and you could be infringing. If you do something bad, you could affect a lot of other students that are confined in that area. So the court said that you have to balance the student's right to privacy with the need of the school to maintain safety and discipline and things like that. So we're still doing the balance, individual rights, Fourth Amendment rights, and the need of the school to maintain order and discipline. And the court said, well, the need to maintain discipline definitely outweighs the Fourth Amendment, not totally, but instead of probable cause, we're just going to require schools to have reasonable suspicion to perform the search. So students in schools do not have the same protection as adults. Schools only need reasonable suspicion to search, not probable cause, which the average everyday student or adult would have a requirement for. Okay, now just within the school. Now, Tammy is accused by another student of having ibuprofen at school, which is a violation of school rules. The principal takes her to the nurse where she is required to strip down to her bra and underwear so the nurse can look for ibuprofen. What do you think about that? Is that a violation? So again, individual rights, huge intrusion, strip search, need to keep the school safe and maintain order and discipline. Which one weighs more? Well, the Supreme Court said that we are going to allow sometimes, as long as there's some reasonable suspicion, so you need reasonable suspicion, but it has to be related to and the objective of the search and cannot be a huge intrusion based on age and the sex and the nature of the infraction. So in this case, you're talking about ibuprofen. You weren't talking about cocaine or heroin or methamphetamine or anything like that. So it's a small infraction. And you also have to look at the age of the person. You have to look at the extent of the search. All those things have to be balanced. So the court wouldn't come out with a bright line rule. They wouldn't tell schools, no, you can't do it. But they also didn't want to take that right completely away from schools. So reasonable suspicion, and the search has to be as narrow as possible and only for really severe types of infractions. So is it important, given the tragic events of new high schools in the United States, that students be searched to verify that they are not carrying weapons? How do we balance the right of students to be safe with the rights of students to privacy? So a lot of schools now are requiring metal detectors and things like that as soon as the person walks into the school. And you have to think about that. How do we feel about that? Making schools almost like prisons where we have to search you and search all your stuff. Is that too big of an intrusion on our Fourth Amendment or students' Fourth Amendments? Or is that necessary to keep schools safe and to stop the school shootings that are occurring? So these are the issues that schools and the courts are always trying to balance. Yes, we're infringing on rights. Are those things necessary in order to maintain safety within our schools? Okay. Now, what about school searches for college students? Do you think college students are treated different than high school students? So Vern is a freshman in college. One day while in class, the police show up to his class and search his backpack. So we said for schools in general, you needed reasonable suspicion for high schools, middle schools, elementary schools. What about college? Do we have the same test for colleges? And the Supreme Court has said they do have greater expectation of privacy than high school students, but we don't really know the details. So the Supreme Court just kind of mentioned in another court case, yes, we do not think high school students and college students should be treated the same. We think college students do have a more advanced expectation of privacy in college, but they never went on to what that means. So does that mean you still need probable cause? In the high schools, you need reasonable suspicion. We don't really have any details on that, and we don't know what that means. But we do know that the Supreme Court has said that college students should be treated differently. Okay. Harry is a sophomore in college. Police asked the RA to open his dorm so they can search in it. We still don't know the answer to dorm searches. And we kind of mentioned this in another lecture. We talked about like landlord tenant and things like that. And can a landlord consent for a tenant? No. We said, can a hotel manager consent for the person staying in the hotel? We said no. So we still don't really know, can an RA consent to allow somebody in the dorms? We don't know that because the Supreme Court's never really answered that question. But it's definitely an issue that at some point will probably be resolved. So do you think it matters if it's a public college versus a private college? Does that affect your decision at all? So if it's all a public school, it's all governmental actors. The RA is a governmental actor. So is the police. If it's a private school, the RA may be a private citizen. And so they are the ones opening it. Does that affect your analysis in any way? It's just interesting to think. We don't know yet. Okay, now let's go into work-related intrusions. So the FBI officer suspected another federal employee of engaging in criminal wrongdoing. Officers visit the worker's office. During the visit, the director of the agency was asked to open the employee's office. The FBI agents look through the employee's office and desk. So it would be like the FBI showing up here at the school and saying, we want to search my office. So they come in and they search my office. Now, the question is it really my office? Do I own the office? Does the school own the office? Is it really my area that I would expect privacy? And the Supreme Court said that in general, work-related intrusions do not violate the Fourth Amendment because I don't own my office. It's not mine. It's owned by the school and I'm not renting it or there's no agreement. So in general, they are going to permit those kind of work-related searches. They are not going to violate the Fourth Amendment. Now, what about searching work cell phones? Is this similar to an office? So if you are assigned a cell phone, can the employer search that cell phone anytime that they want? And this came up in a case called Ontario versus Kwan, okay? And the court said, we're not going to be able to make a hard and fast rule about all technology. Technology is changing too fast. There's too many new things. So we're just going to kind of create a general neutral test. And we're going to say employers can search if it's deemed reasonable, and it will be reasonable if there's a valid reason to search, that the reason outweighs infringement on rights. So again, you do the balance and the need to search outweighs the rights, and it's not excessively intrusive. So in Ontario versus Kwan, there was a police officer and he had a cell phone that was assigned to him. And the chief got the bill and kept getting these huge bills because the officer was using it so much. And they didn't have like unlimited data back then. And so the chief was like, okay, I need to see these records. Why is his bill so much more than everybody else? And when he got the records, it showed that he was sexting with his girlfriend or wife or whoever it was over and over and over. And then obviously he was in trouble for using his work phone for those types of things. And the court, that's what the court was evaluating. What was the reason for the search? They weren't really trying to catch him in something bad. They were just trying to figure out why the bill was more. And they said that was a minimum search. All you're doing is quickly looking at the records. They didn't go through everything in the phone. And so it wasn't excessive. And so it was a minor infringement. And the court said it was okay. Okay, what about drug testing? Opie is working as a bus driver for the town of Batavia. When he arrives at work one day, his boss requires him to take a drug test. Can you, if you work for a governmental agency and they're requiring you to do a drug test, it's governmental action, is that a bad search without a warrant? And the courts have come up with kind of a test. And what they said is there is an interest to stop drug trade. And so we will allow some searches without a warrant. Okay. So we need to stop drugs. So there is some need when you balance, there is a need to do that. Okay. And what the courts have said, there are certain professions that require people not to be on drugs because they could pose a significant risk to other people if they do. So sharpshooters for police, railroad, bus drivers, things like that. If they are using drugs, they pose a significant risk to society. So it is an infringement by doing a drug test, but the need to protect people when we're giving these people such authority in the public outweighs that. So they are going to be allowed to do that. Now, I'm a government employee, but I'm a lowly teacher, and me being drunk or on drugs doesn't necessarily threaten your life on a day-to-day basis. So school teachers would not fit that test, and they probably cannot be drug tested. Okay, so think of it this way. They may be permitted to reduce the danger to public safety. So buses, bus drivers, pilots, railway engineers. So since they are working in a dangerous job, they have lesser expectation of privacy. The need to protect public is higher than your individual rights. And so they're going to be able to do it. Now, the person administering the test, the government, the business requiring the test, has to have policies and procedures laid out. You can't just willy-nilly just do it. They have to have set rules, who gets tested, when they get tested, and they have to follow those same procedures for everyone. So that's that first part of the special needs search. Everybody's treated equal. Okay, so as long as you have those set administrative regulations and you follow strict guidelines, you'll be okay. Now, what about students drug testing? Barbara is a member of the girls softball team at her high school. She arrives at practice one day and the coach requires her to take a drug test. So we said workers, governmental workers can be drug tested. And that, so the one with the governmental workers, the last one, private companies can do whatever they want. We have an at-will employment, right? So if you work for a private company, they can drug test you all you want. There's no governmental action for a private employee. So you have no Fourth Amendment rights. So for that, we're only talking about if you're a governmental employee and work for the government. But what if you're just a student, but you're attending a governmental school? Can they require you to be drug tested? Supreme Court said yes. So the need to keep drugs and enhancements out of sports, we will allow schools to drug test students. That outweighs the infringement on their Fourth Amendment. Plus, they can choose not to do the sport. So then there was a case, Casey is playing the flute in the high school band. One day when she shows up for practice, they make her take a drug test. So can it extend to other things other than sports? Can it extend to other school activities? And the Supreme Court said yes. Any extracurricular activity, if the school chooses to drug test, they can do it. It doesn't matter. But again, they should have set policies and procedures so that they're treating everyone the same. They can't willy-nilly just pick people. They have to have policies and procedures that they treat everyone the same. Okay. Oops, I had my answer pop up. Earl is is admitted to the hospital for pain in his stomach. Without asking his consent, the doctor orders a blood test at the request of police to see if he is under the influence of drugs. The doctor provides the results to the police. And the court had to decide, is that all right? Can the police order the doctors to perform certain tests to gather evidence? And the court said no. Diagnostic tests is an unreasonable search if the patient hasn't consented. So that kind of goes back to the shocking. Are we going to force people to undergo medical procedures? And the court said no. Okay. Now, Andy has been in prison for over a year. One day, the COs just show up and search his cell. Is that permitted? So you could argue his cell is his home, I guess, and it is a violation of his Fourth Amendment. But are we going to limit what correction officers can do when we balance the need to uphold the Fourth Amendment versus the need to keep prisons safe? So are they going to be able to do this? Yes. Oops. Yes, they can. So that's what we call a custody related search. And that is your keyword for this lecture, custody searches. So the keyword is custody searches. Okay. So if you're in prison, you give up that, it lowers your Fourth Amendment expectation of privacy. The need to keep the facility safe is much higher, and they are going to be able to do it. Iris is in prison for a drug charge. One day her son comes to visit. After the visit, they strip search her. So again, Fourth Amendment search, but the need to maintain order. Are they going to allow correctional officers to strip search inmates? And yes, they can. So what if you were just in jail for running a red light? So let's say it's a very minor offense, but you still are taken into custody. The police decide to still arrest you. Can they conduct full searches, strip searches, body cavity searches, even for minor offenses that you pose no risk to society and you haven't given them any reason to think that you're a risk for society? And this came up in Florence versus Board of Chosen Freeholders. And what the Supreme Court said is it doesn't really matter why you're in there. The need to maintain safety and security in the prison allows anybody that's admitted to the prison to be searched. Okay. So you can strip search them, you can body cavity search them, even for minor offenses. They don't have to show that they're dangerous or they present a risk. They are just permitted to search them if they are taken into custody. Okay. So anytime somebody's put into any jail or prison, they are allowed. That outweighs the need to protect the facility, outweighs the need or protections of the Fourth Amendment. So Sam is arrested for burglary. Once convicted by the court, the police come and obtain a DNA sample to run through and store in the DNA database. So the question is this a permissible search? If you're arrested and convicted, can they search your DNA and put you in a DNA database? And so can incarcerated felons be required to provide a sample for DNA for analysis and storage in the database? And the Supreme Court said, yes, you can. So yes, incarcerated felons can be required to provide DNA samples. Okay. So again, I'm sorry, not the Supreme Court, the 11th Circuit. Again, this has not made it all the way to the Supreme Court. It's only 11th Circuit. But so far, the courts pretty consistently have said that gathering DNA, even though it's a search, if you're convicted, the need to maintain that database outweighs any infringement on your Fourth Amendment rights. So Pope is arrested for and convicted of trespassing, which is only a misdemeanor. So the prior case was a felony. Now, what if it's only a misdemeanor? Once convicted, can they take DNA from him for only a misdemeanor and put that in a database? And we don't know. The New York started to do this. So New York was the first state in the nation to expand DNA searches to all crimes. So it didn't matter. As long as you were convicted, they can gather your DNA and they can enter it into the database. So the 11th Circuit said, okay, for felonies, we're still sort of in limbo about whether DNA can be gathered for misdemeanors or violations, but New York is doing it. Okay. Zen is going to the prison to visit his father. Once in the facility, they search him. So now we're not talking about the person that's in the facility. Now we're talking about visitors. Are they allowed? So these are blatant violations of the Fourth Amendment, but are they necessary? Do they outweigh your violation? And the Supreme Court said yes. The same reason why we allow the search of the inmates to maintain custody and order and security and safety, that anybody that's entering the facility can be searched, and it's not going to be a bad search. It is a special needs search, and we're going to allow it. Okay. Now, what about somebody on probation or parole? Does that make a difference? So Yuri is on probation for stealing a car. Probation officers arrive at his home and search it, right? So just based solely on the fact that he's on probation, they show up at the door and search. No warrant, no reason. They don't suspect. They just know he's on probation. And then what about this? Douglas is on parole after serving 3 years in prison for assault. Parole officers arrive and search his home. So does it make a difference if it's parole or probation? And the court said it does, actually. So in order just to randomly search a probationer's home, you need at least reasonable suspicion that something's going on. But for parolees, you don't need anything. You don't need probable cause. You don't need a warrant. Now, there's a little bit of a catch. A lot of times, one of the conditions of probation is allowing the probation officer to search your home. And so you have to agree and consent to those searches in order to get probation in the first place. So although the Supreme Court says reasonable suspicion, one of the end arounds is that the judges require free searches for police to be a condition for the person to be on probation in the first place. So even though this is technically the rule, there's a lot of times where you get around the rule and they can search anyway. So police suspect Flynn of having drugs in his apartment. Flynn is currently on probation. The police contact the probation department and they go with the probation officer to search the home at the police request. So those prior examples were the probation office themselves doing the search. Can they be required to go to somebody's house directed by the police to conduct a search? So it's not just the probation officer showing up and conducting the search. It's the actual police directing the probation officers, and they go with the probation officers to search. And still not decided. We don't know if it matters. It's both governmental action, but since the police are directing it, it's not just part of probation or parole. Maybe they'll have a different result. Okay, so this was your search and seizure flowchart, and we've now finally covered the very last box. So governmental action protected by the Fourth Amendment. Is it a search? Do they have a warrant? Is there a valid exception to the warrant? So if we get all the way down here and it say it is excluded, if it qualifies as a special need search, then it's still going to be okay. So if it's a special needs search, it's good and the evidence can be used. If it's a special needs search that's not protected, then the evidence is excluded. So that's what this last box is. You go through the whole analysis, and if you think, oh, under this analysis, the evidence would be excluded, just make sure you think of the special needs searches and make sure it's not one of those. Because if it's one of those, then you should conclude it's okay. Okay, so that is chapter 7. Like I said, there's no discussion, so just make sure that you read the chapter and you understand those notes. And when you're ready to roll, make sure you take exam number 2. So I will see you soon.